This lecture summarizes some of the issues raised in Chapter 5 of the textbook. And as usual, I'll be going beyond the textbook and raising some other issues. Chapter 5 deals with the court systems in the United States, the state and federal court systems. And as indicated, the court systems are actually the systems that enforce the law. It helps to put things into perspective to consider the fact pattern that's raised in Chapter 5 of the textbook. And it's case number 7. And you'll recall that this case involved a conviction for a murder. And the issues that are presented in the opinion are whether or not the person should factually have been found guilty in light of the testimony of witnesses, both for the prosecution and the defendant. And also there's an issue about how the trial was conducted. And in reading that fact pattern and applying it to the materials in the chapter, keep into consideration or considered what the various roles of trial courts are and appellate courts. Right, as the textbook indicates, one of the main issues involved in any court proceeding is whether or not the court has jurisdiction over the proceeding. And the jurisdiction that we're considering about is really broken down into 2 parts. One, whether or not the court has jurisdiction over the parties to the lawsuit, primarily we're considering the defendant. And second is whether or not the court has jurisdiction over the subject matter of the dispute. So anytime a case comes before a court, those 2 questions need to be answered. Cases in our American judicial system begin in trial courts, and it's pretty much all cases. At the trial court level, the judges and juries are charged with determining what facts are true and what facts are false, and it's up to the court to apply the law to the facts. So we break down these 2 functions into questions of fact and questions of law. And again, questions of fact relate to the determination of actually what took place, who did it, what was done, when was it done, where was it done, how was it done. In contrast, questions of law relate to the interpretation of or application of the law. The textbook raises this issue and describes it in connection with a robbery. And robbery, as defined in the law, is when a person forcibly takes someone else's property. So the questions of fact and questions of law related to that, the question of fact would be, did it happen? How did it happen? The questions of law is there sufficient force to raise to the level of robbery? And also there's an issue regarding the admissibility of evidence. Appellate courts, on the other hand, are a higher level of courts where the losing party in the trial court system can appeal the decision to the appellate court. Appellate courts only determine whether or not the lower court made errors of law. And again, I have to emphasize that appellate courts' review is limited to legal issues. Appellate courts do not review factual findings and determine whether or not the trial courts made proper factual findings. That is the function of the trial court. So if it's a red light case, the appellate court is not going to review the evidence and make a decision whether the light was red or green. That's not the the function of the appellate court. Instead, again, the appellate court looks and sees whether the lower court made errors of law, and in doing that, they rely upon the written record of the proceedings that happened at the trial court. So this written record would consist of the various legal pleadings that had been filed, transcripts made by court reporters of the testimony that had been heard at trial, and a review of course, the evidence that was presented. Again, all to see if the trial court made any errors of law. When the appellate court makes their decision, they can either uphold the trial court's ruling. This happens in well over 90% of all appeals. Alternatively, they might find an error, but hold that the error was so minor as to be harmless, and therefore uphold the ruling of the trial court, or they may reverse the trial court's decision. And the reversal can take place in two ways. One, which is rare, is an outright reversal. More common, if there is a holding of error, is the case would be remanded to the trial court, that it is sent back to the trial court for further proceedings. So, for example, if a conviction was thrown out because of the admission of inadmissible evidence, a typical result of the reversal would be to send the case back to the trial court to actually be retried, this time without the improper evidence. At the appellate level, the parties' names are changed. We've learned that in the trial courts, we have the plaintiffs, the people that start the action, the defendants, and the people that are sued. At the appellate court level, the person that appeals, we call that person the appellant. Less frequently, you sometimes see the term petitioner used. The person that's responding to the appeal, the party that won at the trial court level, we call that person the appellee. Again, less common. You often will hear, sometimes we'll hear the term respondent. Appellate courts, when they reach their decision, they generally will issue a written opinion. And an opinion sets forth the reasoning behind the court's decision. As noted in the slide in the textbook, opinions take various formats. If it's a unanimous opinion, it is just an opinion of the court. If there's a dispute among the appellate court justices, the majority opinion would be the opinion of the majority of the judges that voted to either uphold or reverse the trial court. A concurring opinion, on the other hand, is an opinion where a justice, an appellate court judge, agrees with the majority's result, but not necessarily with its reasoning. So again, the concurring judge ultimately agrees with the decision to reverse or uphold the trial court's ruling, but comes at it a different way. And finally, we have dissenting opinions. These are opinions written by the minority of judges that disagree with the majority's opinion, and they set forth their reasons for that. I put up in Canvas a copy of the decision of the United States Supreme Court in Dobbs versus Mississippi Department of Health. You may recall that this is the decision of the United States Supreme Court that overturned the decision of Roe versus Wade. So I have this up in front of you, and again, if you're interested, you can scroll through this in the modules. I also added some bookmarks to make it easier for you to navigate around the decision. So you see, I clicked out on the left hand the bookmark tab, and I tabbed the Justice Aliotto's majority opinion, Justice Thomas's. They're the concurring opinions by Justice Thomas, Justice Kavanaugh, and Justice Roberts. And then finally, the dissent that was written by Justices Breyer, Sotomayor, and Kagan. So you can, again, navigate around these bookmarks and see how the court ruled and why. One thing you might note, it is 213 pages long. It's obviously a very lengthy opinion, and that 213 pages includes both the majority opinion, the concurring opinions, and the dissenting opinions. Okay. In front of you now is a chart that is contained in the textbook as Exhibit 5 or Figure 5.1. And it's simply a comparison of the different roles of the trial and appellate courts. The court systems in the United States, we have state court systems and federal court systems. The federal court system is established by Article 3 of the United States Constitution. Each state, in turn, has its own court system set up by the laws of the various states. One thing that's in common with all of the court systems we have are trial courts and appellate courts. Most states, including California, have two levels of appellate courts. One's called the intermediate appellate courts, and then the court of the highest level court. And again, these, as the text points out, these courts have different names depending upon the state that's involved. The slide in front of you is a description of the federal court system, and this is simply a reproduction of Figure 5.2 at page 115 of the textbook. And again, it shows the U.S. district courts as the trial courts, the various U.S. courts of appeal, which are the intermediate courts of appeal, and the Supreme Court. The arrows show how cases move up through the various court levels. And again, you can see that on rare occasions, there may be an appeal from a state Supreme Court decision to the Supreme Court if there's a federal issue. A federal issue might be, for instance, if it was a criminal case, whether or not somebody's due process rights under the U.S. Constitution had been violated by a state court conviction. In that case, you might have an appeal from a state court directly to the Supreme Court. Again, that's very, very rare. The district courts, as I said, are the general jurisdiction trial courts. These are the courts of original jurisdiction that actually hear evidence and the great majority of federal cases. Intermediate appellate courts are the United States Courts of Appeal. As noted in the previous slide, we have 11 circuits, courts of appeal based upon a geographical region. You can see a map at page 117 of the textbook that shows the various regions. There's also a DC circuit, which hears matters arising under a federal law from the District of Columbia. And then finally, the federal circuit, which hears other types of cases. At the very top is the U.S. Supreme Court, again, which hears appeals primarily from the U.S. Courts of Appeal. The number of judges in the district courts varies depending upon the size of the district. Large districts like the Central District of California or the Southern District of New York have many, many judges. On the other hand, smaller districts such as like the District of Wyoming or something like that may only have one or two judges. Again, the U.S. Court of Appeal is an intermediate court of appeal, and appeals from the district courts are taken directly to the U.S. Courts of Appeal. There are a number of judges on each Circuit Court of Appeal, depending upon the size of the circuit. And the judges hear these appeals generally as panels of 3, reaching a decision by a majority vote. On some occasions, the entire Court of Appeal may agree to hear a matter. So instead of a 3-judge panel, it would be all of the judges. That's known as an en banc, ENBANC appeal. So again, we have this appeal as a matter of right to the Court of Appeal from the U.S. District Court. The U.S. Supreme Court, on the other hand, hears whatever cases it wants to hear. There is no absolute right to have a case heard by the Supreme Court. Again, the Supreme Court decides what cases it will hold. There are 9 justices on the Supreme Court, and it takes 4 justices to agree to hear a matter. And as the text indicates, approximately 1% of matters that are appealed to the U.S. Supreme Court are actually accepted for consideration. The cases that are accepted for consideration, the reasons for it vary. 2 primary reasons are, one, just the importance of a matter. Again, the abortion decisions show that. And second is when there's a conflict amongst the various courts of appeal. So if you have the second district or Second Circuit Court of Appeal reaching interpreting a law one way, and the 9th District interpreting a law the exact opposite way, the U.S. Supreme Court often will agree to hear a case so they can resolve that. And the idea is there should only be one interpretation of a law, and it shouldn't matter where you live. So the court will often hear that. If the Supreme Court does agree to hear something, usually that's done through what is called a writ of certiorari. Again, that just simply says that the Supreme Court has agreed to hear the case. I need to emphasize, and the textbook makes clear, that even though if a case is not heard by a Supreme Court, they decide not to issue that writ, it doesn't necessarily mean that the Supreme Court agrees with the lower court decisions. It just means that it didn't meet their standards for appellate review, and they decided not to hear that. So again, very, very rare to have a case make it all the way to the Supreme Court. The state court systems are constructed in much the same way as the federal court systems. And again, I need to emphasize that the overwhelming majority of all lawsuits are heard in the state court systems. And state court systems have trial courts, usually intermediate courts of appeal, and then highest appellate courts. I'd like to show you just real quickly some of the websites associated with various court systems. The first one I'm showing you is the website of the United States District Court for the Central District of California. And it's structured in such a way that it has the ability to electronically file things in the courts. You can learn things about different judges. You can find out about the court's calendars, what matters are on calendar, and various procedures. Again, a lot of information here. There's also links to various other websites. And again, you can spend hours and hours going through this. The second site is the website of the Supreme Court of the United States. So again, a lot of information here. You can actually get copies of written opinions, transcripts of oral arguments that took place, copies of documents that have been filed with the court, etc. So again, there's a wealth of information here. The last one is the website of the Judicial Council of California. This is the homepage of the judicial branch of the state of California, and you can find links here to all of the various California court systems, in addition to links to different types of forms, and also sources of law. So if you wanted to find links to the California codes, you could go here. You can also get links to and get copies of various opinions that have been published by the various courts in California. So again, these websites are a great source of information that's made it a lot easier for litigants to navigate their way around the court system. This slide is reproduced from the textbook and shows the organization of a typical state court system. This is figure 5.4 that appears at page 121. And again, it's not specific as to any particular state, but it shows a typical outline of the general jurisdiction trial courts, sometimes limited jurisdiction trial courts, mid-level appellate courts, and then the highest level appellate court, and then ultimately appeals to the U.S. Supreme Court. In our California court system, we do have three levels of courts. The Superior Court or our trial courts. There is a Superior Court for each county. There are 58 counties in California, and depending upon the size of the county and the population, there may be more than one courthouse. If you're interested, you can go to the LA Superior Court's website and look at the large number of courthouses that are in LA County. So again, you can have counties with literally hundreds of judges versus small counties that have one judge. In California, the Intermediate Court of Appeal is, we call that the Court of Appeal. There are 6 districts. These are based on geography. And then finally, the California Supreme Court, which is the highest court in California. The way things go through the appellate system in California are very similar to the federal system, with some exceptions. The California Supreme Court decides what cases it wants to hear. The big exception to that in California is death penalty cases, which are automatically appealed to the California Supreme Court. Again, you can, and this next slide shows the general flow of cases with the outlying ability of or requirement that death penalty cases be appealed to the California Supreme Court. One of the things I did want to comment on is going back to the organization of a typical state court system. In California, our trial court, again, is called the Superior Court. We do not have a separate courts for probate matters or family law matters or juvenile justice matters for that matter. Other states do have separate court systems for those. Some states, in fact, have separate court systems for criminal and civil matters. Again, all of our matters are heard in the California Superior Court, and the Superior Court may be broken down into different divisions or departments, but they're still departments of the Superior Court. So the probate department, the criminal law department, the family law department, all the judges that sit in those departments are regular California Superior Court judges who could be hearing other matters. Okay, the textbook then goes on to discuss questions of whether or not federal laws or state laws apply. I'm not going to spend a whole lot of time discussing that. The textbook clearly sets forth. Federal law are restricted to matters that arise from the U.S. constitutions and statutes that have been enacted pursuant to the U.S. Constitution or regulations. Again, this is reflective of the fact that our federal system is a limited system, and matters not specifically set forth as federal apply to states. And again, so the state law hears the vast majority of cases in the United States. And I want to emphasize that you shouldn't have the idea that federal cases are necessarily bigger or involve more important issues or bigger dollar amounts. That's simply not the case. They just involve federal questions. And again, you can have massive state law cases and claims. So again, people often use the term "don't make a federal case about it." That's a real kind of a slang phrase, and again, it shouldn't be interpreted to relate to the dollar amounts that are involved. Two major forms of federal jurisdiction. One is whether or not a federal question is involved. Less often, federal courts will hear cases under their diversity of citizenship jurisdiction. And this occurs when you have a situation where parties are from different states and the amount in controversy exceeds $75,000. So under a diversity of citizenship jurisdiction, the federal court would hear the matter and actually apply state law to the case. Again, by definition, there's no federal question involved. So the federal court is essentially sitting as a state court and applying state law. The original idea behind diversity jurisdiction was that state court judges couldn't be trusted to protect the interests of citizens of different states. Again, as the textbook points out, this is kind of a dubious proposition, and the federal judges would love to get rid of diversity jurisdiction. Their dockets are very heavy, and they simply don't need these extra cases. The slide in front of you shows figure 5.6 of the textbook, and raises or describes whether or not a matter belongs in state or federal court, and second, whether a state or federal law applies. So again, as noted by the slide, even though a matter may be in federal court, such as under diversity jurisdiction, the federal court would be applying a state law. Similarly, state courts can also hear cases that include federal law claims. And the reason that might happen is that the federal law claims are the type of claims that can be heard in state courts, to be contrasted with some federal law claims that can only be heard in federal courts, such as securities cases, bankruptcy, etc. All right, this next slide deals with that exclusive and concurrent jurisdiction of the federal court matters. Again, some types of federal cases can only be heard in federal courts. This is exclusive jurisdiction. The reason that exists is because Congress said in the statute that only federal courts could hear that. So the bankruptcy statutes, the securities law statutes, patent and copyright, et cetera, all of these statutes provide for exclusive federal jurisdiction. Where Congress hasn't made that designation, again, state courts do have the ability to hear claims arising under federal law. Finally, the textbook summarizes with the description of the roles of the various court personnel. I'll leave it to you to review that carefully. It's indicated there's a lot of people involved in court cases. All of them have their own important role. And again, the court systems could not function without each and every one of the various types of court personnel. All right, this ends the lecture for Chapter 5 of the textbook. Again, this lecture is not purport to be a substitute for a careful review of the chapter, and I encourage you to do so.